school food is like this, I completely missed out. Great job. My name is Dave. I'm an attorney, and who doesn't love listening to attorneys talk about pass the trash in the morning? So I figured I would do what attorneys do, and that is start by scaring the heck out of you. So morning routine, I used to read the paper, nobody reads the paper anymore, so Google News. Anybody here from Hamilton by any chance? Hamilton Township? Right, so, okay, so Hamilton with a smirk on their face, kind of know where I'm going with that. Hamilton's unfortunately in the news this morning because of sexual misconduct by a teacher at a public park against a student. And the principal was contacted for comment, and the article says no comment, right? So, my job, in part, is to do my best to keep principals and superintendents off of that cliff. My job is to try to head this off at the pass wherever possible. So, what could happen in Hamilton, nobody knows if that's, a factually accurate story, but if a student is subjected to sexual misconduct, it is likely that the student and the student's parents are going to be contacting lawyers. In fact, I know for a fact that people like the student in Hamilton, lawyers will find out who that is, and lawyers will contact the parents to advertise for their services. And in a situation that I see similar to Hamilton's this morning, but unfortunately you see these articles all the time. Next week it'll be somebody else, some other town. That school could get sued for things like negligent retention of a teacher, negligent supervision of a teacher. The student can sue the school for a law we call New Jersey Law Against Discrimination. We call it NJLAD. And NJLAD has an interesting component in that, and lawyers love suing under NJLAD, because you get punitive damages. You get attorney's fees. The inside story, guys, with lawyers is all of the lawyers that did personal injury motor vehicle cases, the classic ambulance chasers, right? Insurance companies figured out how to tighten those reins. There are not as many motor vehicle cases in New Jersey now because insurance companies figured out how to drag out cases, pay less money, and many of those lawyers who did those auto cases went into employment law cases. Recently, an attorney that I know and have worked with, Bruce Nagel, up in my neck of the woods up in Morris County, settled a $10 million case with the district, a bullying case. Unfortunately, a young student committed suicide. Settled the case for about $10 million, did not go to trial, settled. What's going to happen is lawyers are going to see that result, and there will be more bullying cases filed. That's going to happen. Lawyers don't know much about schools having to comply with this law. Personal injury lawyers are not so familiar with this yet. Yet. But this will get around the Bar Association, they're going to figure this out. They're going to find a case where a teacher conducted sexual misconduct against a student, and the lawyer is going to find out that perhaps this law was not followed to the T, and that's going to cause a negligence problem in court. You can no longer bring that case to a jury. The school will settle, it will look bad, it will be bad, and it'll be a problem. So what we try to do is head this off at the pass. I'm speaking to a very knowledgeable audience. So does anybody here actually process pass the trash applications for their district? You actually, like, what pain, right? Like, what? It's there. It's a burden. It is not something you had to do several years ago, and now it is a burden. I have a law firm up in North Jersey. I teach at a college, some friends who also do some school law. Do a lot of background checks on when people look for superintendents, when companies look for CEOs, we do social media background searches, regular background searches, so I have experience doing that. Schools would hire me to be litigation counsel when there are cases that perhaps their school board attorney was not going to handle. And I was getting asked by districts and attorneys, how do we comply with this law? How do we do, what do we do? It is a confusing law. Lawyers are supposed to be good at writing, and we write these laws that fairly make sense. And it's not easy to follow. It is in part subjective in its interpretation. And it's new. And it wasn't like, exactly any training given by the state on how to comply with this. Lawyers will be able to poke holes in how schools do this now. As far as we know, there's no auditing going on by the state. We know that this report came out. We know the law is going to change and work, but hey, good luck getting something done in Trenton right now with the votes on bills and laws. When schools and attorneys were coming to me asking what do we do, it got to the point where we said, well, we'll do it coverage. So what my staff and my firm did was we put together a system on how to do this on behalf of schools, so they don't even have to do it. So we're at the point now where we represent some of the largest districts in New Jersey, like for example, Newark, I think is our biggest client in New Jersey. And we represent some of the smallest charter schools. Normally, clients call me after they get in trouble. After there's an article in the paper, I get the call, can you do this for us, can you fix this? And so we come in and do it. But I'm going to explain the process to you, maybe a little bit differently than what you've heard before. And I'm going to pitch my wares to you. If you feel that it doesn't even make sense for your district to do this, then certainly you can outsource it. But be careful who you outsource it to. Talk to your local attorney, your school board attorney about it. But I want to make sure you know those options, and I want to just talk a little bit about the law and where we're going. Because there are going to be changes in this law. Unfortunately, as Colleen asked me before, this law is not going away. It is not going away. It is something we're going to have to deal with. So in this day and age, you have to plan on dealing with that. So these are what laws look like. NJSA 18A. Oh, geez, guys, go ahead. Hey, great food. Great food. NJSA 18A.6-7.6. That's one. So this is the New Jersey law. NJSA, that acronym stands for New Jersey Statute Annotated. This is a state law. That just means you got to follow it, right? You can't be breaking state laws. You got to follow state laws. The purpose of the law, everybody here, I'm assuming, knows the purpose of the law. It is very difficult to terminate teachers based on current contracts, grievance procedures, tenure, and employment laws of the state of New Jersey. It is not so easy to terminate or fire a teacher. Teachers hire lawyers, there's lawsuits, people get involved, and there's a settlement. Settlement agreements are usually confidential. They usually include something like, you can't work here anymore. Okay? And that's how teachers can avoid being fired. Hire a lawyer, file a lawsuit, come up with an employment law claim, enter into a settlement agreement, and you're not terminated. What does that mean? It means you can get a job at another district. If you were engaged in some type of sexual misconduct allegation or investigation, don't necessarily put that on your resume. Right? So this pass the trash law is the vetting process to see if a person was in fact subject to a type of investigation. This law really only finds that narrow group of people that were the subject of a sexual misconduct investigation. It doesn't cover everybody, it doesn't find everything, but we have to do our best to make sure the process is documented in such a way that if a situation like Hamilton happens in your district, you can confidently say, that was horrible, but we did everything right. We did it right. We have a process. By the way, process means nothing unless the process is documented. Unless you can prove that in a court of law, what you do only matters if it is documented. Documented means I can prove it in a court of law. So who's got to do this? Well, you guys have to. I don't know if everybody here is from a public school district, most are. But this law applies to charter schools, it applies to non-public schools. It applies to, some of our clients are very large staffing companies. You guys ever use like agencies to fill in substitute teachers? Some big ones around here, Swing, Delta, ESS. So those entities comply with this law. Do it for them. Contracted service providers with regular contracted students. I can't gloss over that. You guys know that this law applies to teachers. This law applies to everybody in your building who has regular contact with students. Bus drivers. Bus drivers could be internally hired by your district. Bus drivers could be a third-party contracting service, same with janitors. Somebody's got to make sure those third-party contracted services comply with this law. Because I'm telling you right now, the owners of bus driving companies, for the most part, have no idea what this law is, do not care. They're in the business of supplying buses to schools. It's on the district to make sure that those school bus drivers are complying with this law. Janitors, you might say, well, janitors, they sweep at night. Good luck telling a New Jersey judge that a janitor who works in a school does not have regular contact with children. New Jersey is very liberal in so far as our judges are concerned. And generally, school districts treated a little bit like landlords. The preference, the protection is on the side of the student, right? So you guys kind of lost before you invited me. Gotta be careful, gotta be careful. So contracted service providers, secretaries in the front office, administrators, lunch ladies, bus drivers, I should say lunch persons. These contracted service providers have to comply with this law.
Can I ask a question about that, or would you
Please.
prefer
Yeah.
we wait to the end? Okay, so with contracted services, I'm wondering what you recommend, your law firm recommends as far as, how we go about making sure they've complied with this law. We have an affidavit we made up ourselves, like with attorney help,
Yeah.
we made up ourselves and make them sign saying that they've been HIV trained, they've gone through past the trash, but I'm not sure that would satisfy a judge.
It may not, but it's a great start, and I think you're doing the right thing. You're having them make an affirmative representation that they've complied with the law. You've not asked them for the backup, which might be the next step.
Okay.
But you've asked them to confirm they've complied with the law. I think that is a very reasonable step. I think that would pass muster.
And I agree with you that, some contractors have no idea what this is, so if
Right.
they say, because we've gotten this response before, we're not doing that, that's.
It's ridiculous, right?
What is our response, because we can't, finding
Well,
bus
you can't
drivers and
hire.
bus companies is really hard, so we wanna protect our kids, but we have to find a way to get that done.
It puts you in a difficult spot, and it's not part of your normal contract process. So your normal contract process, when I see these bids come out, is, well, you have to confirm you don't work with Iran. You don't work with Russia. You don't donate to the local politicians. It doesn't ask, did you comply with the past trash? I've told a lot of districts and attorneys to make that part of the bid process. It automatically puts that burden on your responsive bidders, but it's not an easy thing to do to explain to the owner of the bus company that there's this law that they have to comply with, and they have no idea how to do it. Now, you're relying on them to do it correctly. They don't wanna do it in the first place. Fraught with danger. Fraught with danger.
Okay, thank you.
14 states have this law, another one is pending. Massachusetts is pending. The laws are very similar between states. We represent districts in multiple states. Some states are more restrictive than New Jersey, some are less restrictive. I'll give you an example. In Washington, D.C., teachers have to provide a character reference individual, and part of the pass the trash process in DC is to communicate with that character reference. So not only are you vetting prior employers, you are, quote, communicating is the law with a character reference. My law firm interprets that to mean we must communicate with that person, not just send an email and not get a response. That's not communicating. So imagine having to keep track of that on top of everything else that you're doing. Not so easy. The list of states appears to be growing. 2 years ago, there were 8 states up there. Now there's more. So I see this as something coming that is not going away. It's becoming more prevalent, and the more prevalent it becomes, ironically, the more we see front page news articles of teachers engaging in sexual misconduct. So what does an applicant do? What does a teacher do? Well, you guys mostly know this. The information they fill out is on an application, and the applicant teacher is providing information to you, to me. We are relying on the information that the teacher provides. And remember, they're not gonna put on their resume that they got kicked out of a district because of sexual misconduct allegations. But they certify on that application that the information that they're providing is truthful. They have to provide biographical information. They have to provide their current employer, no matter who that employer is, whether they have contact with minors or not. They have to provide current employer information. And they have to provide a list of their prior employers for the last 20 years where they had substantial contact with minors. So, what happens when they put down that they worked at McDonald's? Is that regular contact with minors at McDonald's? See, who thinks no? Who thinks no? McDonald's, no. Right? Well, I'd say more than 50% of hands, but who thinks yes? A couple of hands, and evidently a whole bunch of people don't even think. No court has ruled on this yet. So we don't know what a New Jersey court is going to say. I go in front of judges all the time. I am going to take an educated guess that a New Jersey judge is going to say yes, McDonald's, substantial contact with the children. Why? They sell Happy Meals. Some still have playgrounds. No, they're phasing them out. Some, I will say this, many employ their employees who are under the age of 18. And if you're working every day with somebody under the age of 18, then there you go. You have regular contact with minors. I think the Happy Meal is probably the least persuasive word, but I would say I'd be surprised if there's a McDonald's in New Jersey that does not hire anybody under the age of 18, right? So now your coworkers are minors. How can you say we don't have substantial contact with minors? real pain in the butt though, is when they literally just say, I worked at McDonald's 15 years ago in Newark. Right? Well, they're all owned by different franchise owners. We have to do our best to track them down. This is where it becomes a pain in the butt, right? This is a pain in the butt. So, at my law firm, we literally have New Jersey licensed private investigators doing these searches. We literally have attorneys reviewing every search. Because if we don't find or diligently look for that McDonald's, and God forbid that teacher engages in an issue, we need to avoid the principal going on the podium and answering questions to the meeting about why they engaged in the negligent retention of a teacher who had a history of sexual misconduct. We've got to do it right. I told you that not everybody puts this on their resume, right? And you might be shocked to know that some teachers don't even accurately put down the information on their application, even though they certify it's true. You see, an applicant has to certify, meaning tell the truth and sign off on it, that they've never been the subject of any child abuse or sexual misconduct investigation by any employer. They have to certify that they've never been disciplined, discharged, not renewed, asked to resign. They have to certify that. And they also have to certify they've never had a license revoked, suspended, or a license or certificate had to be surrendered. So they certify these things. So what do we do? They certify to these things. What do we do? It should be similar to what you guys do in processes. Well, we have to contact certainly the employers that they've listed on their application. Now, the law says for the past 20 years. Sometimes we get employers listed even further back than 20 years, not too long. What we get? We contact those. Sometimes we get employers that it is kind of clear on the application that this prior employer did not have this person engage in regular contact with minors. Right? McDonald's we talked about. But I will tell you that we've had teachers list accounting firms that they work at. Now, an accounting firm isn't selling Happy Meals. They're not generally employing people under the age of 18. This is an accounting firm, right? But the accounting firm that I'm talking about had a daycare inside. And therefore, I'm sure the judge would say regular contact with minors. So at my firm, we do not discriminate or try to even guess whether the teacher had regular contact with minors. We contact every single prior employer. Every single prior employer listed on the application. We send the certification to the employer, generally by email. Our process, because we do a lot of these applications, we've streamlined it. The teacher applicant fills out their certification on our website. It's all electronic, goes to us, we send out to the employers, they fill it out, automatic process comes back to us. What happens if an employer doesn't respond? Many don't. Many schools do. Most schools are very good at responding because you guys are in the know. But McDonald's, right? You're gonna talk to a manager, they're gonna think you're crazy. What are you even talking about? They've never heard of this. They think it's a scam. They think this is, junk mail. They don't know, right? But the law doesn't require follow-up. We follow up with employers. We do a documented follow-up with the employers. So we just don't reach out once and get nothing. We do a documented follow-up at least once with prior employers. The important part of this, I'm going to remind you, is documenting documenting what you are doing, so that you can go back and say, well, on April 10th, we sent the initial communication to this employer, here's how we did it, here's who did it, and here's the time of day they did it. And when we didn't get a response, we take a look in our calendar, we have the follow-up go, we keep track of the date, time, the follow-up, exactly what it says. An employer has 20 days to respond. If they respond, we populate a document for your personnel file with the response, so everything is up. If they don't respond, you can close out that file in 21 days. We do that. We used to wait 30, we don't do that. We just close it out. If they do not respond in 20 days, we close it out. What happens when they respond 60 days later? Is that time? Well, we take that and add it to the personnel file and document it. So those subsequent follow-ups, we document those as well. But the employer has to fill this out. Getting employers to fill this out, that can be a task. Yes?
So, but you still employ that person?
Yes, there's a contingent basis, that preliminary basis at first. Districts vary. Some will not until it's done. Some will on an interim basis. If it comes back with a positive hit on pass the trash, the law allows the school to terminate it. But what happens if that applicant lies? Okay? And then you find it. What happens if the applicant lies? You're gonna be shocked if this actually happened. Well, there are penalties. There are penalties. So, I think most people here are HR, so you know your grievance process. There is a state law that preempts your grievance process that says if they lied on this form, you're allowed to discipline the teacher and even up to the point of termination. So you can terminate the teacher safely, no matter what your contract says, if they lied on the form. Additionally, there's a potential violation of these letters and these numbers here. What that means, that's a state law. State law, NJS 2C, Title 2C, that's the criminal code of the state of New Jersey. So it is a crime, it is a criminal offense for an applicant to lie on that form. Additionally, they can subject themselves to a civil penalty of up to $500. What really happens though? What's the practical reality? What happens is we get a pass a trash applicant check, we do it. We happen to also do a social media search on applicants to see what's out there. And we find out, for example, true example, that a teacher did not list the fact that they were employed by the Trenton Board of Education, and there were sexual misconduct allegations, and there was a parent referendum with signatures online to get that teacher terminated from the district. That teacher applied for a school district up north, did not even put down that they worked at Trenton. So we do uncover these issues. I'll talk about what our process is when we find issues like that. We call that a red flag. We call it a red flag. We got a red flag, okay? So I'm usually calling either you directly, or the principal or superintendent about a red flag. We need to make sure you guys are aware of red flags. So again, if they provide false information, then there are penalties. If there are willfully false information, there are criminal penalties. But I remind you that for the most part, we are relying on what the applicant tells us. That's what we're relying on, self-reporting. So, our law firm does this. We fell into it because a lot of schools were asking us how to do it. So that's why we started doing it. And we are New Jersey licensed attorneys, we are licensed private investigators. And we do not outsource our work because it falls under the umbrella of our malpractice insurance policy. And when we complete our application process, we provide not just the personnel file with the backup of our search for audit purposes, but we also provide an attorney opinion letter for every single applicant that states that the file was reviewed by a lawyer, and in the lawyer's opinion, the school district followed the law. If Hamilton situation this morning happens in your district, at least you can say, hey, we followed the law. We did this the right way. It's a terrible thing that this teacher might have done, we don't know, but we did everything. The applicant gives us an application online. We find a lot of problems, not a lot, but, you know, they checkmark the wrong boxes. Have you ever been the subject of prior sexual misconduct allegations? Yes. And we get that. I know it's a red flag automatically. I also know that the person may have checkmarked the wrong box. It happens. So we get permission from the district to contact your applicants directly so that we can ask them, hey, you checkmarked the box that said you have prior sexual misconduct. Is that correct? And usually they'll say, oh my gosh, no, that is not correct. Okay, we have them resubmit an entirely electronic application that is correct. If they filled it out correctly, then they're gonna be red flag right off the bat. We will not even contact prior employers, we will just simply contact you or the superintendent, whoever is the stakeholder, to make sure they know there's a red flag. We contact all prior employers. You never know if those are like farm friends. It's a different world, right?
You do.
You guys have a tougher job than we used to get. So I told you we contact all prior employers and we turn it around in 21 days. The entire file goes through an examination process on our end, and we provide an attorney opinion letter along with every applicant check. And some schools like us to email those, we put everything in one PDF, so it's nice and simple. And most schools want us to email those completed applicant checks to them. Some, there's just so many, we create a shared drive. And when we create a shared drive, usually we have applicants in our processing drive, so you can see what's going on. And then when they're done, we move them to the completed drive, and you can see when they're complete. This way, when the teacher calls midstream and says, what's going on, you can say, oh, it's still in process. We're on day 13 of 20. You know, when we were putting these slides together, it's been a while since we put slides together, we're looking at articles to say, hey, you know, these articles happen. This is why we do this. But these articles, unfortunately, are so easy to find, right? Hamilton was this morning, but not to pick on them, but this is Ocean City High School. These articles happen more and more frequently. It's just this day and age. It's just more common. So we're seeing a lot more of this with the pass-through trash bar. Now with the recent SCI report that came out and the recent proposals to change the law, it's not going away. It will change. It will morph. We think there may be a central database coming to New Jersey. DOE might know. I know there's some representatives here. Probably should be a centralized process to do this. Let's be honest, right? Why are you doing this? You're doing it. How much extra money are you getting? It's not going away. So we have to be aware of it. We have to be aware of it in a way where we are going to file lawsuits against your district for the parents of the abused child. Because that's what's going to happen. This law creates liability for your school district. So you have to be careful on how you do it. So what do? Number one, we answer your questions. You do not have to hire my law firm to call and ask any questions of a lawyer. You can email, you can call. I'm gonna give you guys these folders in the back with some information in it. We can email you the slideshow. And you can always call. It doesn't cost you. For districts who hire us to do background searches for applicants, we charge $50. It's a one-time charge per applicant. There is no extra fee. There is no extra retainer. There is no extra hourly rate. It's $50. We do the work first, then we put that applicant's name on an invoice, and we send you the invoice so you can see what applicants were completed, and it's $50. And that $50 frees up your folks from actually doing this, number one. And number two, probably most importantly, gets you an attorney opinion letter on the personnel file to say that it was done by licensed attorneys and licensed private investigators, and it was done in compliance with the law. We turn these around in New Jersey in 21 days. So I told you a little bit about red flags, right? Red flags, these are the problem areas, these are something came up. We just need to make sure that you and whoever you delegate is aware of the fact that we got a red flag. Most red flags are right with the initial application. Most red flags are false flags. The teacher filled out the application incorrectly, check marked the box. They said yes when they meant no. That interaction back and forth is a time suck for the people in your district as well. So we do this. We contact your applicant and get clarification. We contact all prior employers. We look at the employer's responses. Sometimes the employers check mark the wrong box. We say, wait a minute, you said yes. They've been the subject of prior sexual misconduct allegations, and we call the employer and say, oh my gosh, that was wrong. We filled it out incorrectly. We do not want your applicants getting tagged because a prior employer filled something out incorrectly. We do an initial screen, so before we even call you, we contact that prior employer to make sure that they answered the questions correctly. Some prior employers don't respond at all. We document at least one follow-up. The law does not require. We document at least one follow-up because I think a New Jersey judge or a New Jersey jury is going to say, wait a minute, you sent out a random email to an employer, didn't get a response, what did you expect? You didn't follow up with them? A juror is going to say, no, my job, they got to follow up with me 10 times to do anything. They didn't even follow up once. So we do that follow-up. More importantly, we document it. And when there's a red flag, like I said, we proactively notify. We confirm that there's a problem, we bring it to your attention. And I say you, it might be superintendent, whoever you want us to bring it to the attention of, that's what we do. We do provide legal and compliance support. It doesn't cost any extra money, like I said, to call us to ask questions. Most importantly, for what we're talking about today, is we provide this audit trail of what we did and how we did it. That documentation is what will save the day in court. You cannot control the actions of your teachers, but you can control the documented process that you guys are legally required to go through. So we do that for you. And what does that do for you? Well, the concept is it takes a little off. We find that once schools work with us, it's an easy process. Very thankful to be able to not have to do that internally. And our clients include, like I said, some of the largest districts like Newark, some of the smallest charter schools. We represent school districts in other states, and because we've come up with a systematized process, it's pretty straightforward for us to onboard new districts. Onboarding process is generally a telephone call between me and whoever handles it on your end, and we go through what our process is, make sure you know the website to send teachers to fill out the pass the trash forms on our website, and it's an automatic process from there on. So this is my team. This is obviously a doctored photo of me up here. Dr. Shea is a retired lieutenant and professor, dean of police studies at Seton Hall, and now he's got another position. Chief Robert Berry, retired police chief, licensed private investigator. John Birmingham, attorney, myself, I'm an attorney. Skyle is helping me today, who is the valedictorian of Centenary University and looking at going to law school in the future. So these are the people. These people are in New Jersey. These people are here. We do not outsource this. We answer the phone or we answer the email when you contact us. So in conclusion, pass the trash law, the important part of this is you're never going to be able to control the teachers, how they conduct themselves. Very different, right? People, for 99% of the time, that's great. That's not talking about the 99%. My job is not the 99%. My job is to get involved in their own problems. So we try our best to avoid these problems and make sure we have a documented process that will survive in life, that will survive plaintiffs' lawyers filing the lawsuits against the district. I mentioned the law NJSBA. Another cause of action that we're going to see is a federal civil rights cause of action on behalf of the student. Meaning, when a student is sexually assaulted, their civil liberties are also infringed. That means there is a federal cause of action. In that case, it could be brought in federal court. But federal causes of action, there's a federal rule. Don't just name the district. You have to name the individuals who are responsible for negligent causing a violation of your civil liberties. That is why on lawsuits you will see individual people named in the district. I do not want any of you individually named in a lawsuit. Yes, the school is responsible to provide a defense and indemnification for you because you did this as part of your employment, but it's just not fun having to do a lawsuit. We're going to see that more and more as Pass the Trash becomes more well known in the plaintiff's attorney arena. So it's something you guys need to be a step ahead. The way you're a step ahead is documenting the process and making sure that you've got an audit trail that protects you, protects your school. So again, my name is Dave. We're going to hand out these folders with the synopsis of this information. But does anybody have any questions for me? Oh, sorry, saved by the bell.
So the law talks about employee and past employers. Is that, are we supposed to paid versus unpaid, volunteers?
Yeah, good question. Volunteer positions generally don't apply. We just ask for it anyway. And contract. So, volunteer positions, it's really paid positions. But Sometimes people say they volunteered or they were an intern, maybe they did get some payment, I don't know. Volunteer, under New Jersey law, volunteer positions are treated awfully the same as paid employees. So I'm concerned about how New Jersey works.
If we're hiring a volunteer or a sports team ourselves, we're gonna be out those asking for those costs. You know, I'm going to get those as well.
Okay, yeah.
So,
Yeah, not required for volunteer positions. So we do background searches for like chaperones, things of that nature. It's a fine line, but no, not technically.
So, I'm not an attorney, I have the great pleasure of working next to a lot of attorneys, so I
So
run
sorry.
a lot of meetings by them all the time. But one of the things is always to reduce liability, eliminate liability. Can you explain, because the profession of the people here today, you know, I think majority are not attorneys, right? So can you just explain though, the liability aspect, how paying $50 could probably reduce huge liability on the district?
Yeah, so I'm sure that everybody here is interested in saving money for your GS or your insurance. Right, that's good. The truth is, insurance companies and just love us because we take away both of the liability, the exposure that is on the school. We do that in two ways. Number one, we are a professional services firm. Law firms have our own malpractice policy, so our insurance would be involved. Number two, you're not doing the work. You properly outsource the work to licensed firms that do this. So again, it reduces the ability for lawyers, plaintiff's lawyers, to say that you were negligent. You're not negligent, you follow the law. You have a letter from a lawyer saying you follow the law, right? Attorney opinion. So that's how it reduces your exposure, reduces it. Yeah, pretty much. Any other questions? Yes,
what if, so sometimes when candidates fill it out, I notice that they don't fill it out as thoroughly as have their resume would reflect. Where does my due diligence lie in the fact that I see it's on the resume, but they didn't put it on the pass the trash form, so I have to now investigate that for.
So my answer is yes, you do. I do not ask them for their resume. They do not give me their resume. If they did give me their resume and it conflicted with the form, then I would anticipate a New Jersey judge is going to put an obligation on me to figure this out, because I'm on reasonable notice that there's a problem with this applicant, right? So if you get a resume and you get a pass trash certification that conflicts, I think you've got an issue, right? Pass the trash law just says you're allowed to rely on the information given to you that's certified. People don't certify to their resume. So there is an argument that your school board attorney or native from higher would argue in court that you didn't have an obligation to resolve that conflict. I think in New Jersey, it's not been settled in the law, but I think a New Jersey court would say you are on reasonable notice. If there's a conflict, the burden is on you to resolve that. It's one of the reasons we don't ask for resumes.
The answer to this might be, it depends, but what is your role kind of after, if something should happen and end up in litigation? And if you were hired by a district, do you go to court with that, work with the board attorney, or how does that work?
It depends. It depends. Usually, at that point, we are a witness.
Right.
We're a witness, so we work with your insurance company and their lawyer to show them the law, because they're not gonna, and show them the process that we follow, and say, we will support this in court, here's how we do it. So we're actually a witness in that case. So we do, for example, another thing our law firm does is is we do neutral investigations of claims involving teachers in schools. So let's say there's a sexual harassment allegation. Let's say there's a hostile work environment allegation. We go in as a neutral, not as the attorney for the school, but as a neutral, to do an investigation into right of refusal. We are a witness. So that's pretty much what our role is in that section.
If there is an applicant that fill out and they select no for all of the questions, and then you receive it back from a district that selects yes, what would be the next step to call the district to make sure that they selected the correct response?
Yeah, good question. So when we send out the certification to the prior employer, and they come back and they said, yes, the person has been the subject of prior sexual misconduct allegations or investigation, before contacting you and saying we have a red flag here, we contact that prior employer first. And we say, did you fill this out correct? And we know right away, when they're like, oh yes, that is absolutely 100% correct, we know exactly we've got a red flag. But it certainly happened that they said, no, I didn't even say that at all. There was no problem. They check marked off. So we screen that first, and then if the issue remains, then we'll go to the red flag. Otherwise, we'll just have them resubmit a brand new response, not amend their old one. Resubmit a brand new response for audit purposes that says there's no problem. Yes.
And do you send to student teaching experiences, because we get those sometimes, I'm not sure as an employee, but.
Yeah, generally not, because they're generally not listed. They're generally not listed, but if they list it, we'll send it.
I'll stop it. I missed the last meeting, so how effective is this? Do they have any statistics?
No. And if you, the State Committee on Investigation came out with a report recently that's been like the talk of the town in this area. The statistics, are not exactly, in my opinion, supportive of really any opinion, because nobody seems to be doing all this. Nobody seems to be looking into how this is working. It's kind of like a free-for-all. Let's see how people get in trouble, and then we'll fix it later. So that seems to be the situation. Statistically, what I see are very few red flags. We do many thousands of these. And we see few red flags percentage-wise. We also find about the same amount of teachers who did not give us all the information, and we find red flags on our own, simply because I work with, these folks and private investigators. We'll bring that to the attention of the school, but there's no supportive statistics on this yet. And I think there has to be in order to know how to create rules. But that's not the way. Yes, Colin.
At our last meeting, we were talking about institutional abuse and whether something was considered misconduct versus abuse. Is that something your research is able to obtain?
So, no numbers on it, but abuse is part of this process. It's not just sexual misconduct, it's also abuse, child abuse. Child abuse is defined in New Jersey law under Title IX, and it doesn't have to be sexual misconduct. It can be abuse. It can be a fight between a teacher and a student. It can be assault. You'll often see when a student is charged with assault. So simple assault, 2C, 12-1, right? It's simple assault. However, if you assault a teacher, teachers are specially protected under our law, well, they should. Police officers, nurses, doctors, EMTs, protected class of people. If you assault me, that's kind of expected because I'm a lawyer. But if you assault a teacher, it's automatically aggravated assault. Aggravated assault, lowest level of aggravated assault is third-degree crime, 35 years state prison. If you're juvenile, you can be waived up to adult status. aggravated assault. So what does a student do when they're charged with aggravated assault? They go to a criminal defense attorney, and the criminal defense attorney says, whoa, 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 this was a mutual fight, the teacher grabbed the student, let's counterclaim against the teacher for some type of assault, right? And now the teacher who got punched in the face is like, I didn't charge with assaulting the student, but the student filed a claim of assault against the teacher just to protect them as their criminal defense. So you see that happening, and that's a problem. Right? Then that teacher has a potential investigation of abuse on it. We did nothing. But we do look up instances of abuse as well as sexual abuse.
We actually, I didn't attend the last meeting, but we had, after the article came out, a parent reached out to our district, wanted to know why, on top of doing our normal fingerprinting, why we don't have all of our staff have a carry done, for child abuse, which takes up to 45 days. And I'm like, we need a teacher to staff.
Yeah.
You know,
Yeah,
we
it's
can't
not-
wait 45 days for everything to
There's a
come
balance,
back.
right? There's a balance.
Right.
And some states, I told you it was 14 states now, soon to be 50. Some states require a search of every single state's child abuse and sexual abuse registry. And that sounds like you would think that there's like this national database, and there is a national database. But every state has a unique system. And so if a teacher listed, I worked in Arizona, right, or as a teacher, we have to check, or I lived in Alabama at one point in time, we have to check that state's sex abuse registry. And that sometimes means sending a certified mail with a check for $45 to the Arizona Sexual Abuse Registry and waiting, and it's a nightmare, right? There's no easy process for it. Should there be a central database? Unquestionably, yes. It looks like that's the low-hanging fruit of the new law that's going to be coming out. There should be a central database that's easy to go to. There is not right now. And, you know, not many teachers are aware, not many parents are aware. So when parents become more aware, watch out, it's always going to be raining. Like you don't have enough. Any other questions? Sir?
Question about minors that you hire in the summer for summer programs. We have them fingerprinted. Are they also subject to the pass the trash?
Are you paying them?
Yes.
What are they doing? Teaching?
Summer camps,
Summer camps?
count
And the
as
summer
junior
camp
counselors.
is through the district somehow?
Yes.
Yeah, that's a position where there's regular contact with minors through the district. You're definitely complying with this law. If we're not paying them, technically it's a volunteer position to go around. But if you're paying them and they have regular contact with children, even though there's no like classroom, I would say yes, that's good. Yes.
Same scenario, but you're paying them to do painting, move classrooms, move furniture, things like that.
Great question. To me, let's just use janitor as like an example, and I know that's not, work specific, but moving furniture is not super important. If they're moving furniture and kids, with classes in session, and kids are in the school, I would say definitely yes.
But in summer and kids aren't in.
Summer, schools, okay, a little subjective, right? No regular contact with students, and if you can be assured that there's no regular contact with students, then this law would not apply. Okay? So just be sure that there's no regular contact. If there's summer classes going on, and God forbid that contracted third party or that direct hire that you have moving tables commits sexual misconduct against one of your summer school students, the judge is gonna say that law applies.
Question about the logistics of the form. So the candidate fills out just one form to
the state form with respect to the questions. I think that's very important. We're in the state form with respect to the questions, so we have them list all their employers basically in bulk. So we have that, and that information of their prior employers dumps to a database that we use to start the initiation process for their employers. And we use that section of the form where they answer the questions and apply it to each of those employers. So we took the state form, we mirrored the questions to make sure it's not different. And then the way we send it to the employers, by breaking down each employer, having it automatically populate our internal database. We have a case management system that assists us with this, but that's what's important, right? That case management system is the most. And then we send out those same answers to all those prior employers.
So what if you're sitting here and you're like, wow, I didn't do in the past this process perfectly correct, or I hired a janitor and I don't know if I looked through every single job and I said, oh, this one's okay. They didn't have direct contact with children, and now they're working in the school district, and you're like, what do I do now? Do I go back? Do I just move forward doing it a different way? What would you recommend for something maybe you feel like maybe you didn't do perfectly in the past? You just move forward, or do you go back to someone who's already working in the district and ask them to now fill out a form for this or a form for that?
Yeah, great question. I would say you're still ahead of the game on the most part. Some of the largest districts in the state of New Jersey has contacted us years after this law was passed and said, well, we never actually did any of this right.
Right.
Just never did. Just never did. So now we have 2,300 we have to do. Our recommendation is generally, we'll do an internal audit with you to see what needs to be done, and we would recommend it to those folks. Now, a lot of this is within the discretion of your district. My job as a lawyer is to give my clients all the options. This is what the law says. Here's your options. Now you can make an informed decision on what you want to do and how you want to do it. And if the district makes a decision to go back and look to see if it was done right, maybe it wasn't done right, maybe we go back and do everything. And that's part of the audit process. Better that than to have holes in the system that can give rise to liability.
And then I have another question. So say you're the district filling out the form for the district that is then employing, and, you know, when I was working at my old district, a lot of our personnel files were like on CDs, and we would plug the CDs in and names would pop up, and we would fill it out to the best of our ability, but, you know, there was no way of me knowing someone from 15 years ago. And is me seeing what I have enough to check off no, and then give that back, even though maybe you're not 100% sure?
The answer is yes, that's okay. And that, I can say that because the law says, based on the information.
Yeah.
And if you don't have information to the contrary, then that's an okay answer. That's okay.
I'd love to see a solution to this where the state has a database and that when we're doing our criminal history background checks, they're running through that at the same time. I think that's the greatest thing for this room. Do you think there would be an issue with the legality of the state building that database and requiring employers to submit names of people who are under investigation when they left the area to complete the investigation? Like, I can see that being like a gray area with which data are you according to the government about something that wasn't substantiated yet?
Well, I live in gray areas. It's a gray area.
Like, I wonder what the odds are of this happening.
All right, so the odds are good. The odds are good because not enough of you guys have complained, but as we're going to see some lawsuits come down and we're going to see numbers that are very large come in. To give you an idea, for somebody under 12 years of age who's the victim of sexual assault at a daycare or school, we value those cases. We value those cases internally at around $500,000 damages. If there's an NJLAD component, think of punitive damages, 5 times damages, terms fees shift. We're talking about big numbers. We going to see more people complaining, and then we're gonna see people with the pocketbooks to the legislature. I think the law will change. There can and should be a database. The issue I think you're raising is if somebody's under investigation, there's been no conclusion, there's been no due process. And if anybody ever taught 14th Amendment, there's gotta be due process of law. Now you're on a database where you've never gone through a process to determine that you were ever guilty or of anything. And that can be disturbing to somebody. So can they file an action to get their name off that list? I would imagine they're always going to have a right to get their name off that list. I would imagine New Jersey law will allow the list to be populated. Even though there's going to be a mechanism for names to come on and off of that list. So I do see that happening. I don't see it happening anytime soon. I told you that there's a federal law that creates a national database of child abuse offenders. There's a federal law that says the federal government is going to maintain a database. All child abuse cases get reported here with a central database. Great law, it's on the books, it's in writing. Congress never funded the law. $0. So the database was never actually created. There's a law on the books for it. The database wasn't actually created because Congress is not funded. Now, New Jersey would operate a little bit differently. We have another mechanism in our legislature where things have the money behind it. I think there will be a database. They're talking about it. There should be. But you're right. There's some due process problems, right? Even here, you deny a teacher employment because of an allegation that was unsubstantiated, but an allegation. And maybe it's like I just explained, counterclaim by a student just to keep the student, out of less trouble. Even if there's no truth behind it, it's an allegation. All I can say is the law as we have it allows allegations to be enough not to hire somebody or to terminate them during an interrogation.
So we spent some time at one of our last meetings talking about the and some of the concerns surrounding, not that it couldn't be effective, right? But how do you think it would be populated with data? Meaning, right now, all of these forms, 2018, are in local districts. So is there going to be a report out requirement? Is it going to be a prospective? Because then it doesn't work immediately because there's nothing in it. Where does the information come from that populates the database to be used on the effective date of the law? How does that work? And then to the point of what is included, what are the data points? Because the problem is, to the question a minute ago, is investigation was never concluded because the person resigned. So now we're gonna put this person in the database, potentially, and there was nothing that said that they actually engaged in the conduct that was alleged. And now their name is in there. You know how human nature works. They're not gonna be employed because their name is in a database when nothing was proven. And what are the requirements for your name entering that database? What's the parameter? What are the benchmarks? So I think the idea of the database makes sense, but the devil's in the details.
Sure is. And one thing I've learned when I read these laws that come down, and I talk to the legislators who introduce these bills, they don't really seem to care about the onus or burden that they put on the administrative staff.
That's how they got into this battle.
Yes, correct. They put the burden on you. That's why I'm standing up here saying I have to take the burden off. But I don't think that they would have a problem, they meaning our legislature, to say, database, it's populated, here are the parameters under which a school reports. And I think that allegation, I think that will be a violation of due process. And the litigation about this will probably be some type of process by which an individual can get their name off the list. But, devil's in the details. Nobody knows for sure. It's not going to be an easy process, that much I know. It's not gonna be clean, it's not gonna be easy, and it'll be forcing. So hopefully, you have a voice legislation gets crafted. Not an easy solution. We know that the FBI fingerprint checks you guys do on teachers, that's gonna come up with criminal history. That comes up with criminal history. The gap is where a bunch of teachers settle sex abuse allegation cases through a confidential settlement, resign their position, went to another school. That's what this law is supposed to do. FBI fingerprints will never catch that. This is supposed to close that gap. FBI fingerprints, nice, easy process, state does it. This process, complete nightmare, you do it. And you're liable. No easy fix, but I do think that would make sense. Anything that makes it easier, and the state can just say, hey, just go to the database, you don't have to worry about the viability exposure here, right? And that takes a lot of the legal burden off the district. So I think in that respect, it makes a lot of sense.
But there's nothing in the data on day one. Where's it coming from? Because then all 500 districts have to report out what they've been doing for the last 5 years.
Yeah, there's
And
probably
there's
gonna be a
your
few
burden with
times.
that.
Yeah, those, my guess, when they implement laws that create things like this, you'll see lead time and period of time.
Didn't last time.
No.
No, this is rolled out, I mean, this was,
This-
if you're gonna do
the
it.
guidance was not out.
Oh, no guidance on this. Any other questions? No? Well, I remind you that we'll hand out these folders, some information inside. Any questions, my contact information is on here. Business cards in here, cell phone, email, anybody has any follow-up questions, even if it's just, hey, what do we do here? That's perfectly fine to ask any of those questions. So I appreciate you listening to me, and thank you again for the invite. Wonderful breakfast, wonderful menu. I wish all of you